Good morning and welcome back to the Broadcast Retirement Network. This is BRN AM for Friday, October 11th, 2019. Here are our top stories. 403B litigation continues and California passes the Consumer Privacy Protection Act. Welcome back, everyone. And today is Fiduciary Friday. It's a time when we look at the legal goings-on around retirement plans, the markets, technology, personal finance, and more. You know, yesterday we focused on the nuts and bolts of 403B with Scott Downhour. Very insightful, very informative. But did you know that 403B plans are also in the crosshairs for many lawsuits? Joining me now to discuss this and more, Kevin Walsh. He's a principal with the Groom Law Group. Kevin, thanks so much for joining us. So I wanted to talk to you a little bit about 403B plans. Yesterday we had on Scott Downhour from 403bwise.org, went into a deep dive about K through 12 403B plans. But I thought since it's Fiduciary Friday that we would talk a little bit about it from the perspective of an attorney. So why don't you give us a little bit of your perspective on 403B plans today?
So kind of my thought on 403B plans today is that, I mean, just as a little thing, is that when people think about 403B plans versus 401k plans, typically people don't think of there being that much of a difference. Now, from a regulatory perspective, 403B plans tend to be structured as more annuities. There's some kind of nuanced differences, but ultimately what a 403B plan is, it's a lot like a 401k plan in that it's a way that individuals can save through their employer for retirement.
So thanks, Kevin, for doing that. So much like 401k land, 403B land faced with litigation. Is that a true statement?
I think that's an accurate statement. So, I mean, you know, they're similar in that they provide ways for people to save for retirement. They're also similar in that they've got kind of fiduciaries, or they have individuals who are responsible for essentially picking the options that you have available inside the 403B plan, picking entities that are going to keep track of the records and mail out the notices. And when we saw that initial wave of litigation on the 401k front, we've more recently seen kind of a wave of litigation on the 403b side as well. And generally those allegations are that either there's too many investment options with the same provider, or that kind of the fees are higher than it would be for the plan fiduciaries to have offered different investment options.
Now, it's my understanding just from talking to Scott yesterday, that not all 403B plans are subject to ERISA. So ERISA is the Employee Retirement Income Security Act. It is a statute that really has oversight over many of these benefit plans. But Kevin, what you're describing, a lot of these fee lawsuits are focused on ERISA plans, correct? ERISA 403B plans.
Yeah, they're targeting ERISA 403B plans. So typically, you know, 403B plans sponsored by universities that are covered by ERISA. I mean, the ones that come to mind, there's an NYU case, a Vanderbilt case, a Northwestern case. So what we're seeing is, and Georgetown, my alma mater, not that that's a thing to be proud of for your alma mater, but what we're seeing is kind of large universities, and it's not a knock on any of them, are targeted because they are large universities. They have large plans, and there's a sense that should a plaintiff be successful in suing one of these large universities, there could be a significant amount of recovery.
So I think some lessons to be taken away from these lawsuits, and even from the 401k lawsuits, are have a committee. I mean, you should have a committee that reviews and evaluates the plan. Take meeting notes. Right? Take notes and document all the decisions you make. And then from time to time, you need to evaluate your fees. And I'm breaking that down into real simple terms. But did I miss anything there?
So, I mean, my thought is process. That, you know, when someone files a complaint against you, if you're a university or any other plan fiduciary, the most helpful thing that you can have is some documentation showing that, you know, when you made the decision that they're challenging, you had a thoughtful process, you documented your steps, and then at the time, because that's when prudence is measured, it's at the time the decision's made, you were putting the interest of the beneficiaries and participants ahead of your own, and that you had the expertise needed to make the decision.
Now, Kevin, what about these non-ERISA plans? So they're non-ERISA, and not only they're non-ERISA 403Bs, they are governmental plans as well, 457. Will we ever, right now they're not subject to fiduciary responsibilities, but you would think that their retirement plans, they deserve some level of oversight. Is there ever a time that the legislators, the regulators who have responsibility, the Department of Labor, the Internal Revenue Service, et cetera, they look at these plans even more so than they've done and try to put some fiduciary constraints around them?
The world gets super messy once you start getting into governmental plans. And actually, when we think about it, many states have adopted their own versions of ERISA. So for most states or many states, you'll have a fiduciary responsibility for the people making the investment decisions. So, there's federalism concerns. There's whole other things that aren't our bailiwick that come into play when the federal government regulates states. But just because ERISA doesn't apply doesn't necessarily mean that those running the plan are allowed to follow through with the wheel.
Right. So they should take even if you're a non-ERISA plan, you should take fiduciary best practices that you see in ERISA fiduciary 403B, 401k, et cetera. That just seems to be, back to your point about process. That just seems to be a good way to practice. And hopefully that cleans up some of the mess, I would imagine, over a period of time.
I think anytime someone is managing someone else's money or is managing a retirement plan, it's a good idea to really try to make sure that you've got a set of practices that make sense.
Last question, Kevin, for this segment. 403B plans are predominantly focused on mutual funds and variable or fixed annuities. So they're limited investment options. I know that there had been some legislation, and I don't think it's gone anywhere, around what are called collective investment trusts, which allow multiple plan sponsors to it's similar to a mutual fund, but you're buying units of a particular investment and allows you to get economies of scale. Have we heard anything on that piece of legislation? Is that something that, I know we've been talking about the Secure Act and how that has not moved at all. Is that something that even gets considered in this Congress or next Congress?
I think it's an idea that kind of gets bandied around is how do we make it easier to offer kind of the types of products or the same products, or why do we have different options for one type versus another type of plan? Whether we see changes in that, I think people are considering it, but until Secure crosses the finish line, I don't want to predict the next wave.
Yeah, well, I think if I had to be wanted one thing out of the remaining congressional session, it would be the passage of the Secure Act. I think that has the most impact to a lot of people. But you know what it is, Kevin? I don't get to pick and choose what passes, unfortunately, or fortunately for many people. So, Kevin, if you'll stick around, I'm going to go to a commercial break, and we come back. Kevin's going to be with us. We're going to talk a little privacy and some of the new privacy laws coming online in California. So stay tuned right here on BRN AM. Imagine a new television network that will make you richer, healthier, and in control of your financial future. This network is for the policewoman in Nashville, Tennessee, the baker in Dubuque, Iowa, the teacher in Lexington, Kentucky. We want to make the idea of savings and retirement culturally relevant. But what do you see as a defining issue of the midterms, especially for the smaller businesses? They are the lifeblood of the American economy. Featuring exclusive interviews, current affairs, and docuseries. 33 years old, you retired early.
The philosophy is money only matters if it helps you live a life that you love.
But you got to start thinking about retirement as soon as you get in.
The Broadcast Retirement Network will drive very high engagement with premium partnerships. So this isn't retirement and savings for your parents or grandparents. This is for all Americans. And we're going to change the way you think about money. Welcome to the next frontier of retirement and savings. This is BRN, the Broadcast Retirement Network. Welcome back to the program. Kevin Walsh is still with us. We're going to shift gears and talk a little bit about consumer privacy, obviously a big issue this year. Kevin Walsh, principal with Groom Law Group, and he's celebrating his new background today. Kevin, thanks so much for staying with us.
Oh, thanks for having me on, and it's fun to do another segment.
Absolutely. So we're going to shift gears from 43B to privacy. I know this is one that you and I have talked about numerous times on the podcast, but also in the Morning Pulse Academy. Now California is getting in the act with the California Consumer Protection Agency, I think it is. Want to give us a little bit more detail? Did I get that right?
The California Consumer Privacy Act. You were
All
very
right.
close.
I was
know,
close.
great lead-in. So what's going on in California, and just so we can keep it easy, we'll call it CCPA from here on out, is California last year enacted a statute regulating how businesses can use consumer information. And at the time, it was very broad. And one thing that had kind of employers concerned and plan service providers, and even some participants concerned, was that, it didn't clearly say that if you're an ERISA plan, if you're offering services to an ERISA plan, that you can use that information without kind of jumping through the hoops that CCPA imposed on just kind of the general gathering of information, whether it be through internet cookies or just data mining in general. So the big kind of thing this year was that kind of from March on, the California General Assembly first this spring, and then the California Senate this fall, we're working on an amendment, which is AB 25. And what it does is, if it's signed by the governor, it would exempt benefit plans from most of the CCPA's rules for 1 year. So it would eliminate some of the rights, like the right to erasure or kind of more information rights. And instead, basically, when data is gathered, the employer would have to provide some information on the types of data that's being used and how it's being used. And then it would impose a duty on the employer to protect that data, subject to a limited private right of action if there's a data breach. So kind of the reason we're talking about it today is because the governor now has until October 13th to sign it. And the thought is that he's likely to sign it. It passed with large majorities in both chambers. But that's kind of what's going on in California now.
So Kevin, is California the first state to pass such a privacy act, and is this the result of these breaches and Equifax and Marriott and others? I mean, is this really what has created this, and will there be other states that kind of follow suit?
So I think you're asking two great questions, and the first is it's not just the data breaches that have caused this, but some of kind of the ways that data has been used. So we look at the 2016 election, and we look at Cambridge Analytica. There's a concern that individuals might not be comfortable with how companies are gathering and using data today, even if they manage to keep that data a secret. So California is really going at that. And then in terms of what's likely to happen, so other states have begun to get in the game. Early this year, Washington State got very close to passing something. And then on Capitol Hill, I know we've talked about RISA and that bipartisan doesn't always mean a done deal. There have been bipartisan working groups designed to do privacy legislation. So we'll see if we end up with a fragmented framework where every state does their own thing, or if we end up with a national solution at some point.
So let's put on our plan sponsor hat. Those are employers that sponsor retirement plans, and then we'll put on our participant or individual hat. If I'm a plan sponsor, I'm working with a record keeper, I'm sharing data. What types of things should I be thinking about?
So if you're a plan sponsor, kind of the things to begin thinking about are, what data am I gathering? What information is my plan collecting? And then the next question is how is it being used and who's it being shared with? So those are the things that as a plan sponsor, you really want to understand. And if you're uncomfortable with how someone's using the data, it probably makes sense to sit down and have a conversation or pick up the phone and call to figure out if that data is needed and if it needs to be used in the manner it's being used. If you're a participant or beneficiary, I think it's important to realize that the retirement system needs to use data. Without a fair amount of information about who you are, your age, your work history, your address, kind of other information about you, it's pretty tough to give you the benefits that under ERISA are going to be provided to you. But what you can begin to do is you can begin to expect that, there's likely to be more disclosure in the coming years about kind of what categories of data is being used and how it's being used than you've been getting up until now.
Hey, Kevin, let me ask you, this California bill, if it's signed into law, do you have to be a company? So let's think about this. Do you have to be a company based in California? Do you have to have employees in California? Do you have to be working with a service provider in California? Do you have to have data that goes through California? These things that are being kind of fleshed out or will be fleshed out as part of the regulatory process?
So we're expecting regulations, at least draft regulations later this year. Right now, it applies broadly to most companies that do business in California. And I think that's the expectation going forward. The last thing I want to note about kind of the AB 25 with the benefit carve out is that as of now, it's only for 1 year. So
right.
A lot of the questions that you're asking, particularly in the benefits context, there are issues that the California legislature felt it was better off revisiting next year rather than trying to do permanently in 2019.
Yeah, well, that seems to be smart to kind of do things in step by step, because all of what I'm bringing up, and there are probably a litany of other questions that I haven't even thought about in the 25 seconds that we've been talking about this now, probably have to be addressed. So a lot more to come. Privacy, Kevin, I know this is this and missing participants are your top issues for 2019. But privacy, this one, I think this one doesn't go away for a long period of time.
Well, I don't think it does either. And I think both topics are interesting, and there's a tension between the two of them. I mean, you're trying to find people, but you're also trying to protect their rights to privacy.
Absolutely. Kevin Walsh, principal with Groom Law Group. Thanks so much for joining us on Fiduciary Friday. Have a great weekend, and we'll talk to you soon, my friend.
Thanks for having me on, Jeff. Talk to you soon.
Well, folks, that wraps up today's edition of BRN AM. It actually wraps up the entire week of BRN AM. But hey, have a financial topic or someone of interest you think we should interview? Drop us a line. And don't forget, for the latest news, check out today's edition of The Morning Pulse. And you can tune in tomorrow, Saturday, to read the Weekly Pulse. So until Monday, don't forget, keep on saving and also roll with the change.
Waiting here for you to take